are here on Martin versus Allen. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve for rebuttal?
5 minutes, please, Your Honor.
All right, very good. We'll note that you have the 5 minutes. When you're presenting, you'll note to go down to 15 to 5, so don't think when you have 5 minutes left, that's all the time you have on the top screen. If you look, the rebuttal time on the bottom. So when it gets to 5 on the top, you will be into your rebuttal time. I will also remind you at that point.
Okay, thank you, Your Honor.
The arguments are being recorded. Please keep your voice up and remain behind the podium. Also, please identify yourself when you first start speaking, as we're here for the record on the recordings. We want to make sure that's included as well. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child, which I think you have done in this case for some of the folks you identified in some capacity. I'll continue to do that without mentioning names. The judges have read your briefs and are prepared to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Blake Dixon. I'm here representing the appellant, Raymond Martin, who was the husband of decedent Nancy Martin and is now the personal representative of her estate. I represent her estate as well as her family, and none of these are children. None of these are minors. John Martin, Jim Martin, Paul Martin, and Ann Chirac. The defendants have filed a motion to stay in this case, asking the trial court first, and now asking this court to force this case to binding arbitration. We have opposed that motion. The defendants concede that the arbitration does not apply to the wrongful death claims in this case, pursuant to the Supreme Court's decision in Peters. So what we're talking about are the survivorship claims, and are they to be forced to binding involuntary arbitration. Parties also agree that this court's review is de novo. So the only authority for forcing a case to arbitration is if there's a valid contract. There's agreement that these decisions are to be analyzed based on basic contract principles. And in fact, notwithstanding what the trial court said, there's actually a presumption against arbitration when there is a question as to whether there's a valid arbitration clause. In this case, the contract was drafted by the defendants, so it clearly must be construed against the defendants and in favor of the plaintiff if there's any ambiguity to it. We are asking this court to enforce the contract. So Ms. Martin had two different admissions. For each admission, there was an admission agreement and an arbitration clause. The admission agreement clearly provided that it terminated when she left the facility. The arbitration clause clearly provided that the arbitration was merged into the admission agreement. So both agreements, now merged into one, terminated when she left. She was initially there from May 17th, 2017 to May 30th of 2017. So that agreement terminated when she left. She was then there from June 22nd, 2021 to July 12th of 2021. That agreement terminated when she left. We didn't file suit until July of 22. She passed away in November of 21. So when the defendants filed their motion to stay on December 1st, 2022, the agreement had long since terminated. The defendants have cited the severability clause. We're not arguing the severability clause doesn't apply. The severability clause provides that if any portion of the agreement was invalid or unenforceable, it should be severed from the rest of the agreement. We're not arguing that. We're arguing that it's all valid to the extent that the court finds that it even applies to the parties in this case, and as a valid agreement drafted by the defendants, they could have made it say anything they wanted, and what they made it say was that it terminated when she left. So both agreements terminated at the latest on July 12, 2021, long before the lawsuit was filed in this case, long before the motion to stay was filed. In addition to the fact that the agreement, which is the basis of the defendant's motion to stay, is terminated and is concluded, and by the way, we're not saying that it's invalid, we're not saying that it's canceled out. It's the equivalent of, I buy a car and I agree to make equal payments for 48 months. I complete the payments, I get the title to the car. The finance company comes to me a year later and says, hey, you owe us another $450. And I say, no, I don't, I paid. We have a valid contract. Yes, you have a valid contract that was executed and is over. You can't come to me now and say that you're going to continue it. It's concluded by the very language of the contract. Same case here. In addition to the fact that the agreement concluded long before the defendants filed their motion to stay, none of the defendants are parties to either of the agreements. The three defendants in this case are Manor Care Health Services, LLC, HCR Healthcare LLC, and Martin Allen. Manor Care Health Services LLC is in fact named in both agreements. The other defendants are not named in either agreement, therefore they're not parties to either agreement. Nobody signed the agreements on behalf of any of the defendants. Amber Maglianico is the person that signed the first agreement on behalf of the three defendants, or on behalf of the center. We took her deposition. She clearly testified that she was unaware of having any authority to sign on behalf of Manor Care Health Service LLC, or HCR Healthcare LLC, or Martin Allen. And interestingly, even though we're all the way here at an appeal after going with the trial court, none of the defendants have filed any other evidence. You know, Martin Allen is an individual. He's not named in either agreement. He didn't sign either agreement. He hasn't submitted an affidavit saying, no, I meant to be bound, etc. Now that's just the first agreement, which was terminated long before the admission in question. The admission that really is the basis of this case is June of 21 to July of 21. For that admission, we don't know who signed on behalf of the center. The person that signed on behalf of the center, their name isn't printed, they've never been identified, we weren't able to depose them, so the defendants can't carry their burden and persuade the court that that unnamed person had authority to sign on behalf of any of the three defendants, because we don't know who they are. So two of the defendants aren't named in either agreement, and they didn't sign either agreement, and the one defendant is named, but nobody signed on their behalf. Now, the defendants argue that they're described in the agreement. Again, you can't be a party to a contract by description. You know, I passed a car dealership on the way here. I can't go lease a car and sign as the lessee, you know, Blake Dixon and the nice appellate judge with the glasses and the blonde hair who I saw earlier today. I can't bind someone to an agreement by description. In order to be, and we've given you case law, in order to be a party to a contract, you have to be named in the contract and you have to sign the contract, or someone has to sign on your behalf. None of that happened in this case, and again, none of the defendants have since come forward and offered the court any affidavit that said, oh yes, we meant to be bound by this contract, we authorized this person to bind us. And the reason is that other than Manor Care Health Services LLC, HCR Healthcare LLC and Martin Allen will undoubtedly later argue in this case that they're not proper parties to this case, that they're not the owners and operators of the facility, that they're not liable. And so they don't want to come into the arbitration portion and commit to being owners and operators or commit to being whatever. Secondly, even if they are owners, operators, directors, part of the description in the agreement, that doesn't make them parties to the contract. The fact that you're the owner of the facility doesn't make you party to every contract that the facility signs. So the contract's terminated before the motion was filed. The defendants are not parties to either of the contracts. In addition, there are state and federal laws that apply to these, the top one's my 10, okay. There are state and federal laws that apply to these type of agreements. So it's interesting, the trial court actually said in its decision, which I thought was interesting since it ruled against me, this court's of the opinion that arbitration agreements like this one are suspect in terms of their fairness. Because they're suspect in terms of their fairness, there have been legislation passed relative to how these things need to be executed, because historically they have not been executed fairly. And so there's a state law and there's also a federal law. Pursuant to the state law, the agreement has to provide in its terms that the decision whether or not to sign the agreement is solely a matter for the patient's determination without any influence. This agreement does, neither of these agreements say that, and there's a whole section in the arbitration agreement about why arbitration is such a great thing. It's a completely one-sided essay. There's nothing in it that says, if you're the plaintiff and you agree to arbitration, your abilities for discovery are limited, right? One of my big problems with arbitration is I can't subpoena witnesses for deposition. I can't file a motion to compel to get documents that the defendants don't want to give me. The arbitration panel really doesn't have a lot of authority. I mean, I've been in arbitrations where we're waiting for someone to show up for a deposition. They don't show up. We call them on the phone. Where are you? I'm not coming. Good luck to me. Do what you want to do. There's no recourse. The private arbitrators can't issue a citation, can't issue contempt, can't send a bailiff. So also, as we've cited, the facility is very much aware that the verdicts are lower for arbitration. So restricted discovery, lower verdicts, no benefit for the patient. So the state law provides that the agreement has to provide that the decision is solely for the plaintiff with no influence. Also, the arbitration agreement under law has to be separate from any other agreement. And in this case, by its very language drafted by the defendants, the arbitration agreement merged into the admission agreement. So it's not separate. So that's a violation. And also the agreement has to be submitted to a patient for approval, should not be submitted to a patient for approval when the patient's condition prevents the patient from making a rational decision of whether or not to agree. Now, the trial court found that we didn't carry our burden and show that, Nancy Martin, her condition was such that she could make a rational decision. We provided the court with evidence that she was hallucinating that there were donkeys in her room days before she signed this agreement. To me, that seems sufficient to show that she was not rational, that she was not, in her mind. If we look at her death certificate, she died of senile degeneration of her brain, which she had for over a year. And so certainly we think that she was not capable of entering into a contract.
And if you finish that point, counsel, I'll let you know you're in your rebuttal time.
Okay, then I will,
Counsel, have
I have a quick question.
yes.
The trial court found that the contract was not substantively unconscionable and did not rule on procedural impossibility. Is that correct?
I believe so, and, it's always an interesting issue. I don't know that, I don't have to prove that it's invalid 12 different ways.
Yeah.
So, but I do think there's an interplay, right? So the statutes have certain requirements that these agreements don't follow. So I would think you could invalidate them under the state and federal law. I would also think you could invalidate them under substantive unconscionability. We argue both, but I think there's a number of ways that these agreements fail.
Thank you. I didn't want to take more
Appreciate
time.
it.
Thank you.
you have the remaining time for rebuttal.
Morning. Randy Engwood on behalf of the appellees here, who are three parties. There is Medicare Health Services Limited Liability Company, which is the owner and operator of the subject nursing home. The name changed from the 2017 to the 2021. The doing business as name changed between the two admissions, so I'll simply refer to it as Medicare Health Services. It's a limited liability company. It has a singular member, which is in limited liability company parlance, the owner, which is HCR Healthcare LLC. That's my second point here today. The third is Martin Allen. Martin Allen was the director, the only director of Medicare Health Services. He was also the president of the company, making him an officer of the company. Those are the three defendants here, all of whom are alleged to be the owners and operators of the subject nursing home, according to the complaint that's been filed in this case. So that it's clear, there is record evidence as to exactly who each of my three clients are. They've answered interrogatories, which were verified under oath. There was a civil 30B5 deposition taken by Mr. Dixon relative to the ownership and the relationships of these entities. Interestingly, in that deposition, he never asked who's Martin Allen or what's his relationship here, but the court does have Mr. Allen's verified interrogatory answers in the record, so that it is expressly clear. The other is, too, the three answers that were filed on behalf of each of those defendants, both admit or deny the allegations in the complaint and also avert particular facts relative to who they are and who they are to one another, meaning the parent, the subsidiary, which is the owner-operator of the nursing home, and then its director and its president, who's an officer of the company. So we're here today to talk about an arbitration agreement. There's actually two, either of which we contend could apply to the claims being made in the complaint filed in the trial court. There is no dispute in the record or in the argument made here today from Mr. Dixon that Nancy Martin signed each of the two arbitration agreements. They've never contested her signature on either of the agreements, so that issue is not before the court. Both of the agreements were signed by individuals who are identified in the agreements as the, quote, center representative. On the line indicated for them. One of them, Amber Maglianico, did in fact print her name, which is clearly legible on the 2017 arbitration agreement. She was deposed in the case. The court has heard transcript of deposition testimony in the record. The second agreement was signed by an individual who we could not definitively identify. But the fact of the matter is, there's a signature on it under the header of Center Representative. It's a document that was kept in the ordinary course of the operations of the nursing home, and we are not contesting or disputing that that individual had the authority to sign as the Center Representative on that agreement. I emphasize at the outset the parties, the relationships of the parties, and the evidence in the record. Because Mr. Dixon just stood before you and said that none of the parties are parties to the agreement. That is patently false. The agreement says, right at the top of the first page, it identifies the center. And who is the center? The center is Manor Care Health Services, LLC. That is a party to this case. That entity had a corporate representative testify on its behalf. That same person also verified interrogatory answers for it. All would say, I own it, I operate it, and in fact there's a license issued by the state of Ohio for it to do that. It's very clear, Manor Care Health Services, LLC is identified in these agreements. So to say that none of the parties are parties to the agreements is just, I don't know where we're going with that. Center is defined in the agreements. It's defined to include the center's licensed operator, which is Manor Care Health Services, its officers and directors. Under both of those titles, you have Martin Allen. Its members, which for a limited liability company is the owner, who is HCR Healthcare LLC, which is also its parent company. That is another identified party to the agreement under the definition of center. So this notion that none of the defendants before the court are parties to this agreement is belied by the four corners of the agreements themselves. Your Honor, you had asked the question, did the trial court only reach the question of substantively unconscionable and not get to procedurally unconscionable? That's the way I read their decision, the trial court's decision, but they did that because the person challenging the agreement has to show both procedurally unconscionable and substantively unconscionable. So if they can't prevail on one, the court need not consider the other because they can't get both of that. And in this case, the court didn't go into in-depth analysis on the second because they didn't prove the first. And that is a true read of that decision from the trial court. Generally speaking, arbitration is favored in the law. Here in Ohio, nationally, we have statutory framework for this. There's a statute that specifically applies to the arbitration agreement here before the court. It's 2711-23. It informs the court as to what must be in the agreement to make it substantively conscionable. And as it's demonstrated in the briefing and as the trial court found, all of the elements of the statute are identified in the agreements and they're satisfied within the agreement. So there's no real ability to challenge the procedural unconscionability of the agreements because it mirrors the statute that applies in the case. Relative, since this is de novo review, relative to procedural unconscionability, the court in the first instance looks at capacity, then at relative bargaining position of the parties. And in this case, there is some question with regard to Nancy Martin's capacity when she signed the agreement in 2021. Mr. Dixon referred to days prior in her medical record before she got to the nursing home. It was noted that she was having some form of hallucination or seeing something. There is nothing in the record to suggest that by the time she arrived at the nursing home, she lacked capacity to sign the contract. Beyond referring to, and I think submitting a singular page or pages out of a medical record, none of that was put into evidence. There is no verification that those records are where they came from, or they are what they say they are, or where they came from. There's otherwise no testimony from Mrs. Martin's husband, who would be probably in the best position to say whether she was not of sound mind and body when she got to the nursing home. There's no affidavit from him. There's no clear and convincing evidence, which is the burden that they have to prove that she lacked capacity. Relative bargaining position, this court, the 9th District in the Brosville case, says that mere inequality of the parties' positions does not render an agreement unenforceable. You know, she was afforded first of all, the arbitration agreement is not mandatory. She was in the nursing home, she was in a room, she was going to stay there whether she signed the arbitration agreement or not. It wasn't a condition of her staying. She had the choice to say no. The 2021 agreement also includes an affirmation at the end of it where she indicates that she read the agreement and she acknowledges that my signature below indicates that this agreement has been explained to me and that I understand it. That's right there then above where she signs the agreement. So there's no question that she took the time to read it, she understood it before she signed it. They're not challenging the signature. There's no clear and convincing evidence that she lacked capacity. There's no evidence that the agreement is procedurally unconscionable. These other arguments that Mr. Dixon makes, that we're forcing anybody to do anything, that's simply not true. As I said, she was admitted to the nursing home. She was there. This is a voluntary agreement. She didn't have to sign it to stay. Nobody forced her to do anything. It's not involuntary. In fact, right at the top of it, and all over it, it says voluntary, again and again and again. It's the opposite of involuntary. This notion that discovery can't be had in the context of arbitration is belied by the fact that the arbitration agreements themselves say that they are subject to the Federal Arbitration Act. Federal Arbitration Act, his comment about subpoenas, authorizes the issuance of subpoenas. You get to do discovery. It's not a blind situation where you don't get to engage in discovery just as you would as if you were in the trial court. It all gets done just the same, it's just in a different setting. So for those reasons, the reasons set forth in the appellee's brief, based on the record evidence before the trial court, including those discovery responses which are verified in sworn deposition testimony, we believe that the trial court should be affirmed and that the arbitration agreement should be enforced and the case should remain state pending arbitration.
Okay, if I understand counsel's argument, we have a separate arbitration agreement and admission agreement.
Correct.
Both sides. And that the language of the agreements indicate that everything is merged into the admission agreement.
That is true. There is a merger clause in the arbitration agreements. And if you follow his argument then to the admission agreement, which by its terms terminates 15 days after discharge, and that necessarily terminates the arbitration agreement, you have to look at the arbitration agreement itself, and including the severability clause, which is paragraph number 13, and it reads as follows. Severability. The parties agree that the only essential term to this agreement, meaning the arbitration agreement, is the agreement and willingness of both parties to arbitrate. Accordingly, if any provision of this agreement is determined to be invalid or unenforceable in whole or in part, the remaining provisions remain in full force and effect. The parties very clearly express over and over again, Your Honor, in the arbitration agreements, their willingness to arbitrate. And the severability clause says that's the only essential term to the arbitration agreement. So
Does the admissions agreement have any reference to the arbitration agreement?
It does not, no, because the arbitration agreement is a standalone. In fact, the admission agreement is not dependent on the arbitration agreement also being signed.
I didn't know that any reference as well to it one way or the other. So the admission agreement is silent arbitration, separate document, the whole content of the arbitration agreement.
Correct. Correct.
And are the parties the same as the admission agreement and the arbitration agreement?
So the admission agreement is with Medicare Health Services LLC and the patient. The relationships of the parties are still one and the same. Martin Allen is still the director of Medicare Health Services LLC. He's still its president.
In the description, the same. So the definition of party to the agreement you gave me earlier, with that definition from the arbitration agreement, was that from the admission agreement? Are they the same as far as you know with both agreements?
I can't say with certainty off the top of my head, Your Honor. We do have the admission agreement in the record. It's appended as an exhibit to the deposition of Amber Maglianico. If you'll humor me here for a moment. So the admission agreement, it defines the center as Manor Care Health Services LLC. And it does not offer any more detailed definition of the center than identifying the limited liability company that owns it and operates it per its
So
license.
that first definition you gave us as you started, that was a definition from the arbitration agreement?
That's correct.
That's the definition of the form.
That's correct.
And the testimony and affidavit provided by that particular witness is only relevant to the 2017 document, correct?
Amber Maglianico's testimony, yes, she was employed there, she was the admissions coordinator at the time, and she sat with Mrs. Martin and signed the documents. And I think one thing too in that regard, Your Honor, on the process and what went on at that time, the transcript and the exhibit to it includes, and I don't have the count off the top of my head, but there's upwards of a dozen different places where the two of them signed documents and when they sat down on, I think it was May 18th of 2017. And you can see there's a number of things there. The process didn't change markedly, if at all, between 2017 and 2021 when she returned to the facility later. And the other thing too is, if there's any perceived or alleged defect in the 2021 arbitration agreement, the 2017 agreement was still in force and effect, even relative to the 2021 admission. It was there, and it indicates that it applies to I apologize.
Let me just, we'll obviously review the record.
Sure.
But the alleged acts occurred all after the second admission.
Correct, 2021. Yep.
Thank you. If you have time, any brief conclusion?
No, Your Honor, other than we'll see another briefs in the record before the court.
Thank you.
Thank you, Your Honors. So to clarify, we honestly said initially that HCR Healthcare LLC is named in both agreements, but no one signed for them. Amber Maglianico testified she was unaware she had authority to sign for them. The second agreement is, we don't know who signed. Mr. Engler wants you to believe that even the first agreement was still in effect. But again, in order to conclude that, you have to ignore the clear language of the agreement drafted by the defendants. It terminated when she left. I mean, the agreement from 2017, it's not in effect in perpetuity. It ends. That they decided to draft it that way. Who knows why? But that's what they
You're referring
decided.
to the admission agreement.
Correct. Correct. Which is
What in the admission agreement leads you to argue that the arbitration clause is included in that admission agreement?
well, the arbitration clause, which is part of the packet, which is given to them as one, 30 pages altogether, clearly says that it's merged into the admission agreement. So if we're here to enforce the arbitration clause, let's enforce the arbitration clause. It says on its clear language that it's merged into the admission agreement. The severability clause has no effect because we're not asking you to invalidate any portion of either agreement. They're not canceled, they're not invalid, they just ended. I'm sure this court hears contracts every day that have a finite term. They're not in effect forever. They're in effect for a period of time. You hire somebody for a period of time. You do a car lease, you do a car loan. It's a period of time and then it ends. One of the things that's really important comes up in every one of these cases, you can't contract by description. Mr. Engler mentioned all the evidence in this case, but in none of that evidence did Martin Allen say, I'm a party to this agreement, I gave authority to either Amber Maglianico or the unknown person who signed the second one to sign on my behalf. I am listed in this agreement. and the defense has not offered you any case law that says, or any court's ever concluded, that you can contract by description without a signature. We've offered you ample case law that says in order to have a valid contract, you have to be named in the contract, and you have to sign it, or someone has to sign it on your behalf. That's not a dispute. The agreement clearly violates state and federal law, as we've laid out, and I didn't get to federal law in my initial thing. Federal law requires that the arbitration clause be explained to Nancy Martin. Raymond Martin signed an affidavit saying nobody explained arbitration to us. Now, Amber Maglianico, who signed the first one, testified at her deposition. She doesn't understand arbitration at all. I asked her a whole series of questions that are in the brief, that are in the record. Is there a judge? I'm not sure. Is it one person or multiple people? I'm not sure. Do they get paid for their time? I'm not sure. What's your understanding of what it is? It's mediation. She had no understanding that this is binding arbitration that gives up your right to a jury trial. So there's no way she could have explained that to the Martins, but we don't have to guess, because Mr. Martin attested in his affidavit, no one explained anything to them. They don't understand arbitration. They don't understand the difference between arbitration and litigation. They're not sophisticated when it comes to judicial proceedings. And so there's a violation of federal law. Again, Mr. Anger wants to differentiate between hallucinating with donkeys 2 days earlier, and then 2 days later, there's no evidence she was seeing donkeys that day. She did die of senile degeneration of her brain. Mr. Englewood says there's no verification the records are valid. The records we cited are their records, they're the defendant's records. These are their recordings and evaluations of her conduct.
How about note you're out of time?
Okay. So, in conclusion, by its very face, the agreement's both terminated long before the motion was filed. None of the defendants are proper parties to the agreement, and the agreements violate state and federal law. We'd ask the court to rule as follows. Thank you.
Thank you both for your presentation today. The court will take the matter under divided initial decision to force the clerk of court to mail a copy of the decision to you when it's released, and the opinion will also be posted